Here's what I have, counsel. I have his phone at the scene where this body is.
And I'm just going to give an admonishment. I'm not making any accusations or anything. There are a number of people in the courtroom. Any outburst, anything will not be tolerated. You will be removed. If you keep giving me problems, you'll be taken into custody. And there'll be no questions asked. I hope everybody is understanding.
I think everybody understands.
Court does call the case of the people versus Fareed. Is it Hajar?
Good afternoon, Your Honor. The court please Mark Krieg on behalf of Mr. Hajar.
And Ryan Murad, PA 3665 on behalf of Mr. Hajar. Stand present to my right. Sir, please introduce yourself to this honorable court.
My name is Fareed Hajar.
All right.
I would give my P number, but I don't want anyone knowing how old I am.
They didn't have them then, did they, sir? No. Everybody knew each other.
My partner, he started when there was no P number.
Got it. All right. This is your motion. He can have a seat.
Thank you, Senator. I have filed a brief, but I have some supplemental information. Your Honor, I understand, and I did listen to the bond hearing, that there is an active homicide investigation going on. I spoke to Mr. Surma at the Wayne County Prosecutor's Office, who is overseeing that investigation. And I've spoken to Ms. Blanche, and she agrees. Here were the representations. The cause of death has not been determined. The investigation is open. There is no timetable as to when that will be completed. And it's not even clear at this stage that there is a homicide associated with the body that was found. I indicated that he is a longstanding member of the community. He has lived in this country for over 40 years, over 40 years. He served in the military and the Marines, and I have a picture, Your Honor.
The courtroom is immediately put on notice as the judge warns that any disruption will lead to removal or custody. A high-stakes case is called involving a deceased victim and an active investigation.
That verifies his service in Marines at Desert Storm. To say that he has community support is a gross understatement. Present, I'll just give a number of people who would vouch for his credibility, for his desire to appear at all of the cases to defend himself on these charges. First is Oscar Garza. Would you stand up, Mr. Garza? Mr. Garza is a retired Detroit police officer. He was a sergeant in the K-9 unit. He has known Mr. Hajar for approximately 40 years, has known him since high school. He has never known him to be violent. He has one prior misdemeanor from 2012. That's a DWI, which he received probation and successfully completed probation. I don't know if the court had an opportunity. I did give the court the URL for the Zoom hearing on
I review all of them whenever I have a motion, so I'd seen it.
Okay, so all he said was he has, quote, the potential for violence. Outside of this offense, there's no history of violence. If he's charged with murder down the road, which certainly is an open question, so when you're charged, you're presumed to be innocent. You would assume even more so when you're not charged, and that bond can be appropriate. Judge, I'm not asking here for a personal bond, although quite frankly, under the court rules, I don't think a personal bond would be out of order. I'm asking for $100,000 10% bond with a GPS tether. He can only go to work, to medical appointments, and religious services. I think that is an absolutely reasonable bond. There's no history of flight. If the court has questions, I'd be happy to answer that.
In terms of the coordination, because this stretches over 2 counties, and you indicated that you talked to somebody from Wayne County.
Correct.
And maybe Ms. Blanche will answer this, so I was holding off in terms of the question. In terms of the murder investigation, as well as the potential charges, who would have those?
They would be our jurisdiction. So I don't know why Wayne County would say that it's their jurisdiction, because we actually sat down and had a briefing with Wayne County Prosecutor's Office, Dearborn Police, Northfield. They were present. The body is located in our jurisdiction. So if we can't prove exactly where. Let's say it comes back as she's strangulation or something, it happened on a high, I mean, the jurisdiction would be where the body's.
Body
So
is,
right now,
correct.
we have jurisdiction. If we do declare homicide, it is going to be in our jurisdiction right now. But obviously we are not there yet, but this is an ongoing active investigation.
Well,
And I-
and that just so that you know, and I sorry to interrupt you there, but that's why when you said about Wayne County, I was curious because it would seem to me that, at least from the sketchy facts that I know, that it would be here unless there was something else.
If-
It would be here.
May I, Your Honor, and I
Yes.
can expand upon that a little bit. We've spoken, and I think she would agree with what I'm about to represent to the court. Wayne County is also involved in the case because they don't know where she died. And we don't know whether it's a homicide, but I spoke to Ms. Blanche and she agrees that it's an open investigation. No charge has been brought. There's no timetable, and they have not even at this point determined that homicide is the cause or the manner of death. To hold this man on a $2 million cash or surety bond without even know whether it's a homicide and under what circumstances, I think is antithetical to everything that this country stands for, that someone's presumed innocent. He has not been charged. If he's charged, then whether it be in Wayne or Washtenaw County, then the court can set a bond that it believes appropriate for a murder, depending on whether the proof is evident or the presumption great. But the $2 million cash bond on offenses that theoretically the guidelines are 0 to 17 at best, and like I said, at worst 19 to 38 seems to me to be a violation of the 8th Amendment and the Michigan Constitution. If the court has questions, I'd be more than happy to answer, but I don't think I've made any representations today that Ms. Blanche would disagree with in terms of the homicide investigation.
Well, besides, I didn't want to get into the autopsy or what has been conducted so far because it isn't relevant to the charges yet. Correct.
Right.
But the fact that he's making these representations in court, medical examiners are medical examiner in our jurisdiction, and she did say that the circumstances are consistent with homicidal violence. That is, last time I talked to her, she's still waiting for the toxicology. It's pending. We won't know cause and manner until after that is done, and she wants to, hold off on drafting the autopsy protocol. But that is all we have right now in terms of whether or not this is a homicide. Obviously, it's still being investigated, but I'd like to speak just now based on the charges when I can on why I would like the bond to continue as it is.
And if, Your Honor, homicide charges are brought, I will make sure he surrenders himself.
Yeah, but counsel, if I were to have that preliminary finding, and I realize it's not a finding, but that this is consistent with homicide, then I have what was, at least from the documents filed by the parties, that there is some connection there. Why wouldn't I take that into account? I mean, what would be inappropriate, I guess, with the court taking that into account?
What I think would be inappropriate is that he hasn't been charged and he's presumed to be innocent. But let's assume that you can take it in. I think a $2 million cash or surety bond is still excessive. I mean, I'm not, like I said, I'm not asking for a personal bond. I'm not asking him.
Yeah, but counsel, what I'm getting at is you're indicating to me that there's no determination that it's a homicide.
I was not aware that there was a preliminary finding.
Right. I understand. I'm not saying that you're trying to misrepresent anything to the court. That by no means am I saying that. What I'm indicating, though, is that you want me to take into account sort of the absence of something where there's something going on and I now have something else, but you don't want me to take that into account. And I don't know that courts operate that way.
Okay. So let's take that into account. Then I think a $500,000 10% bond would be reasonable, but a $2 million cash or surety bond, it's no bond at all. And even on a homicide, bond may be denied. There's a recent Supreme Court case, bond may be denied where the proof is evident of the presumption great, but does not necessarily have to be denied. You can get a bond on a murder case where the proof is evident and the presumption great. It's permissive as to whether you remand somebody. But on the charges that he's facing now, he's entitled by the Constitution, both of Michigan and the United States, to a reasonable bond. And for a case.
I'm hearing you, but I'm just saying the idea of what's going to be a reasonable bond is in a lot of ways also, you certainly laid out the factors in your brief, but it's also the circumstances and sort of context that I'm operating in as to what the reasonableness of that bond is.
Okay.
I mean, certainly that has to be taken into account. This becomes a different type of case in certain respects because there is this ongoing piece of it.
If the court does not feel my suggestion of $100,000 10% bond is reasonable, then the court can set some other bond, but 2 million cash or surety, no 10%, I just think is far excessive given that what he's facing now carries under the guidelines, in worst case scenario, 19 to 38 months.
Okay. And I'll certainly let Ms. Blanche argue, but one of the things that I'm to understand is that there is, so a couple of things. One, that there may have been misrepresentations as to the knowledge of the individual to the police by the defendant.
That's been an accusation. I have not seen any discovery yet, so I can't speak to that. I've been told that there was a false exculpatory statement made. I'm aware of it.
Correct. And also phone tracking data. So, and my point to that is this, and I don't know how much of the discovery you've seen, what you've seen or
none.
not. If you're telling me you haven't seen any, then I don't know what I necessarily do with that. But as I'm to gather from this, were this a circumstance of he knew the person or saw the person, saw with the person, nothing else sort of connects them there, and then the person a week later is found dead, I certainly get your point. I don't think that's what I have here, which places this, at least for me, in a different posture. Because and I'll certainly let Ms. Blanche give the argument and the information to the court on that. But from what I gather here, I have, I think, his phone in the township, in Northfield Township. I have, so he's sort of tracked to where the body is.
That's my understanding.
And also,
bond hearing.
well, right, but then also that there is video where the defendant is in the presence of the decedent in this case. So it certainly, I'm not operating in the vacuum you like for me to operate in, because I think I've got something wholly different here. Now, there may be other explanations for it ultimately down the road. I'm not making that type of finding, but I can't leave that out and just ignore it either.
Okay. I get that, Your Honor. That's why I'm saying if the court doesn't feel $100,000 10% is a reasonable bond, then the court has a variety of bonds, $500,000 10% bond, $1 million 10% bond, but a $2 million cash or surety bond is no bond at all.
Your Honor, I would just argue that the factors that the court's relying on, what's been placed on the record, I still don't think is a nexus with a homicide charge. I think with count 1 and count 2, that's what the court's laying on the record here, is that if someone was allegedly found in a certain area, but there's been nothing placed on the record that tells us there's a certain dispute or certain violent tendency, certain behavior that my client is responsible for this. That has not been laid on the record. What's been laid on the record here is supporting evidence for count 1 and count 2 of this charge, not of any unrelated charge. There's been nothing before us that said that there was some sort of issue.
Counsel, let me just stop you there for a moment, because there's a bit of a problem here.
Why is that? Your Honor?
Because yes, that's what you're dealing with at this point. But I think that goes to then ignore the fact that there is this continuing investigation into a homicide. And then with the information, just the brief information that was presented by the people, that what they're, at least the medical examiner is seeing, is something consistent with a homicide. So, and I'll let you finish your argument, but I want to make sure that that you understand how I'm seeing some of this. And that is, if on the surface of it, something is consistent with a homicide, and then I have not just the defendant in the presence of that person, but then I have tracking data that would place him in the township near the body, I'm looking at something totally different. I get what you're saying in terms of the charges, but that becomes problematic, I think, from the court in terms of the setting of the bond and release conditions, because this is something that is fluid. So go ahead.
And ultimately, just to finish off, Judge, I don't see that anything's been placed on the record, despite everything that's been placed on the record, that a GPS tether, any sort of confinement provision with that 100,000, 10% would not be sufficient to protect any community. I mean, he's hired attorneys. He's going to be confined to his home. He's going to have to put up money. I mean, we have almost this entire community here behind us. We have his 87-year-old mother who lives with him, who he's caring for. He has his 2 children. I mean, his ex-wife, I've never seen an ex-wife come and support any of my clients, Your Honor, in court. So I think we have the community.
You just don't know the good ex-wives. Go ahead.
My ex-wife came to my
I don't know.
My ex-wife came to my second wedding.
And just to finish this off, Judge,
Yes.
I'm not sure how many times the court hears this, but I've met with Mr. Hajar. I've met with his lovely family. I really, really think that this is an amazing person. I think he's going to adhere to any of your conditions. I understand that there's a serious situation going on, but as it relates to bond, I don't think that that anything's been placed that tells us he's going to violate a confinement provision or that he won't surrender his passport. He's willing to do all of this, Judge. And we have no problem with him doing this confined to his home and paying at least $10,000. But I'd ask the court to just keep that in consideration when ruling on bond.
Ms. Blanche.
Judge, obviously the victim is deceased in this case. This was called in as a missing person. Her last phone location was at the defendant's house. They went to go question the defendant. He said he doesn't know who this person was. And then they started gathering his coordinates of his phone along with video. And based on the video, the victim's last seen going into his house, she never leaves. His car at, I think it's early in the morning, you see his car lights come on, off, and then you don't see the defendant leave his home until later in the day when he tracks up to Northfield Township, and her body is located in the place that his phone coordinates and his car. There's video, different places up in Northfield Township where he's roaming around, and her body is then discovered a week later. So she's last seen going in his home, she never leaves, and then her body is recovered a week later up in Northfield Township. I think there's huge grave concern for the community safety. He's been dishonest with police. He acted like he didn't know her. Then he said, oh wait, yeah, I do know her. She was at my house, but she left earlier in the morning. So there is concern for community safety. And the fact that on the records in place, well, a GPS tether would be sufficient here. That GPS tether would tether him to the home that this allegedly took place at. The fact that we have a missing person that was last seen in his house. So we have a GPS tether at that house with also, he lives with his mom and his kids, who his mom, I believe, was present at that time. So you have witnesses, possible witnesses, that haven't come forward to the police or even been honest in this, and we want to tether him to that house. Judge, I'm sorry, but there's a huge issue and huge community safety based on misrepresentations by this defendant, and then also the circumstances surrounding this case. So no, I'm asking you to continue the bond, the $2 million bond. I believe it's reasonable under the circumstances. I was asking for a $10 million bond. If this was a homicide, I would ask you to deny bond. But we are asking for a bond. We're not asking you to deny bond. That's not appropriate under the court rules. The $2 million, yes, according to community safety, I believe it is.
Just briefly, Your Honor, if the court thinks he shouldn't reside at his own home, maybe we can make arrangements that he could live with one of his friends, his brother, or a close friend. So there was a Detroit police officer who's known him since high school. I'm not saying, Your Honor, again, I don't want the court to misunderstand my argument. I am not saying that you shouldn't at all take the homicide investigation into consideration. What I am saying is, even if you take it into consideration, he hasn't been charged with it, and a $2 million bond is no bond at all. I mean, if you wanted to go to a bail bondsman, you'd have a $200,000 premium that would be non-refundable. They don't have that kind of money. So again, maybe he can raise some money with friends and family. He's obviously got a lot of support, but it ought to be some kind of a reasonable 10% bond. That's all what I'm asking.
But Counsel, you would agree that the reasonableness, I mean, one of the things that you're arguing to the court is that he's not a danger to the community. Correct? I mean,
No.
go ahead.
I don't think that's not the standard. The standard is, are there reasonable conditions that can assure
It's a
the
huge
safety?
factor.
It is.
I mean, that's a huge factor.
It's an important factor. There's no question. But the question are there conditions that can be imposed that would mitigate that danger to the community? Nobody can say anybody is never a danger to the community unless, possession of.
Okay, but Counsel, maybe you're not following what I'm saying. What I'm saying is this. If on the one hand, and I just hypothetically place an extreme out there of, I guess the extreme would be, in my mind, what the prosecutors laid out in terms of the woman goes into the house, she never comes out. He is seen leaving. We have his phone then in Northfield Township. We have her phone at his house, so we know that they're at some point together. That's one extreme. If on the other extreme, I just have, okay, she was at his house, but at some point she left, her phone is someplace else or goes someplace else, and then something may have intervened that happened differently. You'd want me to take that into consideration in terms of setting bond, because that would cut against him being a danger.
I don't want the court to think that I don't think that danger to the community is not a relevant factor. I hear the court completely. I've been doing this for 44 years, and I get where the court is coming from. My point isn't that danger to the community shouldn't be considered. My point is that the bond that is set is unreasonable. And you can consider in determining what the appropriate bond is. It doesn't need to be a $2 million cash or surety bond.
Maybe you
A $2 million 10%
maybe
bond.
you agree or disagree with this, but the reasonableness, especially if I were just using the one factor of danger to the community, the reasonableness of that bond that I may set is certainly going to be dependent in some way with the risk that I see.
Correct.
Right?
I agree with that.
So it really requires me to sort of analyze what's there and what risk is there. I never forgetting he's presumed to be innocent. I'm not saying that, but just in terms of the risk of what evidence is there. I'm having a difficulty here at this particular moment because I don't want to, I want a full fair hearing for anybody that comes before me. When you indicate to me that you haven't seen the discovery in some of the stuff that's coming out, and I'm not saying anybody's playing any games, I'm not saying any of that. I would just like the full-fledged argument. There may be a reason, if true, and I have no reason to doubt it, that her phone tracks to his house, which may be inconsistent with statements that he's given. There may be some reason for it. Where I'm at right now, and I understand why you brought the motion when you did, but where I'm at right now is that gets put out there. I don't have anything on the other side of that. And there may be, and it may be unfair for me to be looking from that for that from you if you haven't seen even the preliminary parts of
I-
the discovery?
The only thing I know is what I listened to at the arraignment and the bond hearing at the arraignment. But let's assume if let's say this was a murder, which it's not at this stage, and the cause and manner of death have not definitively been determined, I think a $2 million 10% bond would be reasonable. So what I'm saying is the court should not have to punish him and make him pay a premium of $200,000 that is not refundable. So make it a 10% bond, Your Honor.
I don't think this court gets in the business of punishing people with bonds. We just don't.
But again,
But counsel, some people, sometimes the prosecutor thinks maybe the court's being too lenient or letting people go because of the bonds that we've set. Then there's defense attorneys that get all upset with us saying we're trying to punish people by the bonds that were set. I can tell you every judicial officer in this court, and I know certainly for me, I'm looking at a number of different factors. I rely upon counsel to give me all of those factors. I factor in all of the things that you pointed out. Factor in, is this person going to be a danger to the community? Is there a way that I can, given the circumstances of what's going on, safely release this person into the community and the like? Go through that whole analysis.
can I throw something out to the court that I think?
Can I stop you? Probably not.
You
So
probably-
go ahead.
If you told me no, I would keep my mouth shut. I can tell you that. I've learned. Judge, the difference between a $2 million cash or surety bond and a $2 million 10% bond, the only difference is either way he has to put up $200,000. Either way he has to put up, but one is refundable and one is not. And even the $200,000 10% bond, the court keeps $20,000 of that for administrative costs. So all I'm saying is, Judge, if you're going to make him post $200,000, if he shows up, which is certainly isn't chump change, $200,000, that is a significant bond, and he forfeits it if he violates it in any way. And if the court feels that he should live with his brother, who would ask as a third-party custodian, so be it. But I'm asking, Your Honor, that all I'm saying is, even when you consider the homicide investigation, that a $2 million cash or surety bond is excessive. That's my argument, Your Honor. And whether,
Well, you just said two things to me because I'm trying to figure out,
Okay.
and I want to make sure I'm getting your point. I understand you're saying that it's excessive. You're also making the argument, I think, that even if the net dollar amount's the same, that when all's said and done, somebody, whoever would put that up, would like to get some of it back.
well, the bail bondsman doesn't get it back.
Oh, I know. I am aware of that.
But also, the difference is that he could possibly raise $200,000